Your client dispute that?
Yeah, my client disputes that. He agrees that there was a constitution that has been drafted for purposes of submissions to the revenue services to have the IPHC recognized as the public benefit organization and for other tax-related issues. So he deals with that in his affidavit. But he disputes the suggestion that that would have replaced the existing articles of association. And then it's important to see which entity is incorporated.
Yes.
Because it's the same name. If you go to the name of the company under section 011-87,
yes.
Item 1, say the name of the company is the International Pentecost Holiness Church Association Incorporated under Section 21. So there is no dispute that it was an association of persons. But we say in 2003, it ceased to be an unincorporated association to an incorporated association. And then it now governs by the provisions of the Companies Act because now it is a company. So, and then you see it goes, if you look, there are identical things in the 2007 Constitution that they rely on. And of course, there are some things that are not consistent with the article. And then I can tell you why I believe that the applicants and the first respondent would prefer to rely on the Constitution as opposed to the article and seek to disavow the registration. It's because the article and the 1989 Constitution, which is incorporated in the articles, does not make provision for a council of elders that they rely on as the entity that will run the affairs of the church. It specifically says who should run the affairs of the church. Of course, the comforter is at the helm of everything, but there's an executive committee, which is the directors in terms of the articles of association, which are responsible to day-to-day running. And of course, if they were to rely on the registration, I mean, they wouldn't be here. And that's why the third respondent is taking the point that this was an opportunistic move for them to say, because there was a constitution in 2007, we can ignore the articles.
So just one second, Sonia. So everybody in the audience is incredibly hot. So I'm just wanting everybody to open some doors so we can get some air in there. Mr. Mpilo, what comes to mind is I don't have to make a finding about whether the NPC is the correct juristic person or whether it's the voluntary association. The fact of the matter is, though, that there is this dispute of fact to which the NPC probably should have been joined.
Yes, yeah, but
isn't that the point?
That's the point. The third respondent is obviously not asking you to make that finding.
Yeah.
The third respondent simply said to your lordship, this is an interested party. Whether you agree that the church, all rights and obligation of the church vest in the NPC or not,
yeah.
This is the interested party.
It must have an opportunity to state its case, is what you said.
Sorry?
It must have an opportunity to state its case,
you say. And it's important because now we hear the fourth respondent, the organization that is represented by our learned friends, now to be the IPHC. And that is problematic for a number of reasons. This is the organization that is run by the very same council, which, contrary to the very same constitution that they rely on, in their own admission in the affidavit, has approached the first respondent to take over the position of the comforter. Their constitution says, well, the late comforter, the leader, must make that decision. So the council has appropriated that power to itself and so we are going to approach the first respondent because we need a leader in the church. So that is the very same organization that is being called the IPHC. And then you would have seen in the condonation application that, sorry, I should have moved that first, because there was a condonation for late filing of the answering affidavit.
Is he in opposition?
I understand it's not opposed.
No, not opposed.
Yes. So in that you'll see that the IPHC, the NPC, was actually placed under provisional liquidation for the debts which were incurred by one of the factions, not the directors of the NPC itself. And then they tried to resist that to say, well, this must have been an agreement with someone else. And then the court non-suited the NPC and said, well, these are the factions of the one entity, which is the NPC. And that's why it was liquidated. And it had to discharge that debt for it to be discharged from liquidation.
Is it still under liquidation?
It was in provisional liquidation, yes.
Has that order been discharged?
Yes. The annexes is in the condemnation application, giving the reasons why the answering affidavit was delayed. Because after the service of the application, it was discovered that the NPC is actually placed under a provisional liquidation. My client is one of the directors, in fact, it's a lead director in the NPC itself. And it was, of course, with the second respondent at some point, but I don't know, I think the second respondent is still the director there. We just need to check them. So that is why it ended up there. So it cannot be a situation correct for the applicants to say the NPC is a defunct entity. You would have seen there is an attachment, a report which was a recent report in 2024 when the answering affidavit was filed. The CIPC report, which confirms that this NPC is still in business. And then it shows there have been a movement, the exchange of directors, and like I say, it was at some point liquidated. So, and then it was discharged. So
was the provisional order discharged?
Yes, if I may, maybe the annexures to that effect.
I've got the CIPC report.
The CIPC report is the 2004 report. That shows that it's still in business. But when you go down to item 22, last two items is the provisional order. And then I think CON2, I lost my name. CON2 is the order discharging the provisional liquidation. It's common cause.
Okay, I've got it.
So the point we're simply making is that the IP has been joined. It should have been joined. We agree that it's a fatal non-joiner. And then in the answering affidavit, the third respondent did say to the applicants that there must be such a joiner, and if that joiner is not happening, and the matter had to be postponed for that reason, if the matter is not going to be proceeding for that reason, because we cannot see how you can, unless you dismiss the application, of course, which is what we will be asking at the end of the day. But if you were to grant the relief that has been sought, you cannot do so without having the IPHC properly before you. So that point is very fast. So the second point that we are raising is the factual disputes. And Leonard Friend dealt with that, but we come from a different point. We say the applicants approach you on the basis that the late comforter passed on without legally identifying a successor. That is the bone of contention. That is what gave rise to the whole previous litigation, which was eventually withdrawn, and then whatever that we see everywhere. So that is where it started. So it's not correct for them to come to you and say, we are coming to court because this is what happened. It's a dispute. And then my learned friend
I understand that.
Yes. For the first respondent say, well, the applicant, my client went to court to claim that he was a comforter. The interdict is annexed. What my client was seeking was simply to interdict the respondents in that application from interfering violently with the arrangement of his coronation ceremony. He was not asking the court to recognize it. He said, I have been anointed, and then the arrangements were made, then the disruption started. So that's all that it is. So, and then it's been spoken many times in such a way that it may sound like that is actually the correct narrative. But the interdict is there for everyone to read. He doesn't sit there. The reason he tells you where the problem started. And if you look at the whole debate, Comforter passes on in 2016. The very same year, my client assumes the position of the comforter. Where is the first respondent at that time in 2016? We don't know. He doesn't feature anywhere. Where is the second respondent at that time? Of course, the second respondent supports his brother at that stage and say, well, as a part of the family, and the confirmatory affidavit that is filed, that the late comforter has appointed him as the leader of the church. 2017, he's still at the helm of the church. Where is the first respondent? Nowhere to be found.
The point is, Mr. Miller, is that I'm not called upon to decide who's the comforter.
No, you're not.
What I have to take note of, it seems to me, is that there's a substantial factual dispute of who's in fact the successor. That's it.
It's not, I'm happy to leave it at that. The reason I was addressing it is like,
I know there's a serious dispute about
there's
a massive dispute of fact. You're right.
As the court pleases. And then we also take a point that the applicants have not met the requirements of an interim interdict. And so we say not even one requirement has been met. You see now in the heads of argument. The first we say there's no prima facie right that will require irreparable harm here for purposes of an interim interdict. Because the applicants say to you, they've been attending church after the comforter's passing. All of them. Until the first incident of violence in 2018, when allegedly the second respondent came and started to say, insult the congregation. And I'm saying allegation because that's what they allege. My client is not involved in that. So the first question is that their religious right, they say, no, you must interdict the third respondent from holding himself as a comforter because we are unable to exercise our religious right as long as he's there, and then there are two other respondents who are fighting him. Then the question to be asked immediately is that, what happened in 2016 when he asked and he assumed the position? They said we continue to practice our religious right, no problem. What happened in 2017? We continue to do that. Then what is the reason that you suddenly stop? It is not the third respondent, but it's what was happening between the first and third respondent when they were fighting in Silo. Because the third respondent tells you that their family was unlawfully evicted from Silo because that's where the headquarters of the church is. And then all the late comforter's family was living there. So some people are now, at some point it was occupied by the first respondent, and then now it's the second respondent. But he left there peacefully. He's accused of going to Springs. He said, well, where should I go? Springs is also one of the properties of the family. Then he went there. Nowhere you'll be told that, well, we could not exercise our religious rights simply because the third respondent is claiming to be the comforter. On what basis then, what right do you require a protection against the third respondent? There is no right. The Section 15 right, you continue to practice them. All the rights that you give, your right to dignity. So, well, they were assaulted. By who? No, admittedly, they do not point a finger at the third respondent.
I understand your point.
Yes. So that right, there is no right to be protected. We also deal, of course, if there is no right, then there is no irreparable harm. But if there was an irreparable harm, obviously it comes to, to demonstrate that there was no irreparable harm, you look at the delay that it has been taken. It's since 2016 up to 2024 when they brought an application. If indeed there was an irreparable harm, I don't know if anyone of them...
Let's be generous and say that's at least 6 years.
Okay, 6 years. None of them would have been here. So it's clear that whatever harm. But what is important is that they do not complain of any harm to them. They give a general statement to say the members of the IPHC in general. But that statement is also not correct. And then we take the point in the heads and in the answering affidavit that it will actually be unconstitutional if you were to grant an interdict. I'll tell you why. Because the religious rights of those members, at least, who believe that my client has been anointed and is the leader who is rendering those church services to them, if he is removed, the IPHC is no longer the IPHC that we used to know. They take the important, they're concentrating on the assets of the company. Some violence, whatever that is happening in the company. which is of course not an unimportant issue, but that is not the main business of the IPHC. You will see in the articles and even in the Constitution, the main business of the IPHC is to preach gospel and to heal the sick, and they are spiritual items, and which cannot be done by anyone other than the anointed one, the comforter. Then these applicants come and say, no, you must remove anyone who claims to be a comforter. I'm not speaking about the second and the and the first respondent. I'm just speaking on behalf of the third respondent. What about those members who say, we believe, it's our religious right, entitled to believe that he is the chosen one, and we are following him. And then now this court is going to tell them, no, your marriages can never be blessed this coming Easter or coming marriage season. Your children will never be blessed. There will never be all these ceremonies or services that are conducted by the comforter, because the third respondent, whom they believe is the right leader, has been removed.
I understand the point.
So that's the point making. That it will be their constitutional rights to practice their religion freely will simply be limited by that particular order. You simply cannot cross that border. And then the other requirement is the alternative remedy. In paragraph 227 of the heads of argument, we suggest various remedies that they have. We say even if the third respondent is wrong, the Constitution prevails over the articles, there are remedies in terms of the Constitution. Unlike the first applicant, we don't say go to the internal structures of the church. But we say, to the extent that there is a looting, which is something that they complain about, or the misuse of the assets, the IPHC will have remedies. Even the criminal conduct. The first remedy for IPHC on the assets will be to obviously sue those who would have misused those assets. But you would see there is no evidence whatsoever as far as the third respondent is concerned to say you flouted any financial policy or whatever that has been done. I know there may be a dispute in another matter, but certainly in these interdict proceedings, there is nothing of that sort. There is no evidence like that. So we list the remedies that they have. They can obviously seek protection. Insults that is a level on them. They are being assaulted or insulted by whoever other than the third respondent. So all the four requirements have not been met. And then we conclude by saying, even if they were met, in the exercise of your discretion on the delay point, you should not grant the interdict. It will not be in the interest of justice. So I think those will be our submissions for the third respondent. The first thing is say both the points in limine should be upheld, and the application should be dismissed on that basis, on the basis of a fatal non-joinder, on the basis of a dispute of fact, which was clearly foreseeable, because this very issue of the succession was referred by Justice Colopen to trial. And they say, well, we spent months going through that litigation history, and they talk about it in the papers. So they knew that whether or not the comforter has passed without leaving a successor is in dispute. They chose to approach this court on motion proceedings. So we say on those two grounds, it must be dismissed with cause. We asked for attorney and client costs because we say this was just a waste of time. We warned them, and then I give you reference.
If I grant attorney-client costs whenever it's a waste of time, I'm going to be doing it virtually every day. But it was also not a bona fide application in the sense that when we take the point of the non-joinder, I think every applicant, my client admits on papers that in 2016 when he instituted the application, he made the same mistake. And then he thought, well, the Constitution is actually the one that governs. And then it was later then brought to his attention. There's an email from a senior counsel who was involved in that stage to say, well, this is the problem that we have. That's one of many other factors that he took into account when he withdrew. So when this point is raised, I don't think there's any reasonable. The first respondent are saying we don't agree with the third respondent that the NPC is in charge, but we agree that it has a direct and substantial interest in it. So we say on that basis, the cost order is justified. And then if you're not with us on the merits, you still have to dismiss because
none of the requirements of the document were met.
Thank you.
That was our submission.
Thank you. I'm going to take an instruction. Sorry. Mr. Osborne?
May I just mention the costs issue just raised by my learned friend for the third. We of course do seek costs, and we seek costs on scale C in light of the, first of all, the complexity of the matter, and then we submit also that the court is entitled to take into account the fact that they are manifestly and patently too late, and they should have been aware of that. And for whatever it's worth, we suggest that that contributes to finding under scale C. In the ordinary course, we go no further than that.
If I am with you, which I haven't made up my mind about yet, are you looking for cost of two counsel?
Yes, indeed.
Cost of two counsel. Right, thank you.
And may I say one thing in response to my learned friend for the third respondent? We have not, they are seeking no relief against us. There's no counter application. We are seeking no relief against them. So we have made our arguments as to what we see as the complete illegitimacy of the third respondent. It's in our heads, but that's as a matter of background. We're not advancing that because we don't think it's necessary for the reason that
for the purpose of this application. Yes. All right, understand. Right, Ms. Barrera. Can I just ask if it's about 10 to 1. I'm not sure how long you're going to be, but I think it's important that we finish because there's lots of people standing outside.
Indeed.
So if we can conclude the matter, it would be great.
Indeed, my lord.
Can we continue through lunch?
If we can take a 10-minute adjournment, just for me to take short instructions,
of course.
And then we can proceed if the court staff.
Ms. Gillison, are you two happy to continue? All right, we'll resume at 1 o'clock then, shall we?
Yeah, so 2 days was just
Then multiply again.
because he also holds other roles. He works with that executive committee on financial affairs, etc., etc.
As a piece of sport, Harold van Loon's colleague, the third respondent, says that the 27 constitution is not a valid constitution because they rely on the articles and it's based on an email. If my Lord has regard for that email precedes the constitution. That email is 2003. So based on that, myself and my colleague Mr. Osborne are on the same page that...
Sorry, just run that past me again. The email is 2003.
Yes.
That's when the NPC was incorporated.
Yes, my Lord.
Yes.
But then it became a voluntary association, apologies. And we are saying that the NPC should not be cited in this because we are merely at this point seeking the spiritual side of his church to be sorted out, to be determined. That is the point of the applicants in this regard, my Lord. We're saying that we joined all the necessary parties. Everyone was able to give their part or give their version of events. And the issue before this court is the leadership within the association, not the corporation's rights or its assets. We are merely seeking like a comforter, or that the three comforters is restrained from acting as three, and that decisions be made to get the church back to having one comforter, one faction, my Lord.
Okay. What do you say about Mr. Mpila's argument? This is quite interesting. That if you were to remove the comforter of this, the third respondent as comforter, there are apparently thousands of people who are of the view that he was properly anointed as comforter, that you would be interfering with their religious rights. Quite an interesting argument, isn't it?
It is an interesting argument. There's nothing in my papers in respect of that
Yes.
that I may address the court on. We are merely stating that the current instability is not the objection of the current constitution, the valid constitution. If my Lord understands.
I still don't understand why there was a 2007 constitution if there's an NPC registered.
My Lord,
There's this thing about what you show to the taxman so you can get a break on tax.
my Lord, I have no submissions in that regard as I have no instructions. But from that constitution, my Lord, we also noted that the initials on there appears to be that of the previous comforter, Mr. Comforter Modise, as it coincides with these
Yes.
initials and all that.
Yes.
Obviously, he is unfortunately no longer with us to
explain.
in that regard. But my Lord, the fact of the matter is, and my colleague Mr. Osborne and I are in the same boat there, is that the 2007 Constitution is the only valid one.
Well, there is another dispute, isn't it?
My Lord, but we are not seeking final relief in this. We are seeking that the spiritual leadership of this church be sorted out through the exco and the council.
I know, understand.
My Lord, and in the event that that is done, it might even resolve a lot of the relief that is sought in Part B, but be that as it may. My Lord, in terms of the locus standi, I've addressed this not specifically by stating locus standi in my chief address, in stating that the Constitution doesn't make provision for determination of the membership.
But it does say that members will be subject to disciplinary steps. Whatever those steps might be is not included in the 2007 Constitution. So it seems that there must be other rules somewhere. I don't know if they're written down or whether they a matter of custom, which will be enforced.
But my Lord, there's no evidence provided in this regard by either of the respondents that
No,
there is
there is.
determination.
Yeah, there is. The first respondent says to you, he says expressly, we've got a custom in this church. If you don't come to church for a specific amount of time, you're not a member anymore. How is that contrary to the Constitution?
My Lord, as I said, as my Lord now stated, there is customs, but there is not a direct provision in the Constitution that states termination will occur when this and this.
No, you're right. You're 100% right.
However, can we find in the papers of the the applicants, specifically paragraph 19 of the replying affidavit, the applicants come in and say that they didn't know who to go to, which comforter, which faction. They want to be participating members of this church. They make that clear throughout the application. rights are being infringed in that there is now 3 factions, 3 companies.
Why don't they choose one and go there?
My Lord, because
Whoever they feel comfortable with. That's what we all do. We all find a church to be comfortable with.
My Lord, because remains one church, one constitution,
No, I get
and
that.
it ought to be.
I understand. It ought to be, yes.
And
But
that
are
is
their
the
religious
church.
rights infringed upon?
They are contending, and it is our strong position that it is. But my Lord, further to the locus standi, the first applicant himself is still a priest in Namibia, in a branch in Namibia.
So his religious rights aren't infringed because he goes to church.
He goes to church, he's a priest at the church, but he has not associated with one faction as he wants to associate with the church, not a faction.
Okay, I get it.
But his locus standi especially cannot even begin to be disputed. He is still an active member. No one has removed him as a priest. Does that not give him the inherent locus standi rather?
I'll think about it, Ms. Pereira.
As it pleases the court, my lord. As I've stated now, in terms of the other members, they make it clear they don't want to be associated with the faction because that was not the intention of the church. I've belaboured that point now, unless my lord has any other questions in terms of the locus standi.
No.
My lord, my learned colleague, Mr. Osborne, referred to, we have had the opportunity to join the action proceedings on many occasions. However, what he did not say to the court was that that action proceedings was instituted after this application, as far as my knowledge goes. So we had instituted this proceedings first, and then the action proceedings followed.
Why don't you consolidate them?
My lord, it was my instruction, and I contend that this interim interdict will probably, if granted, or not probably, will, if granted, propel this matter forward and propel the church's exco and the council to consolidate and to sit and make decisions which will already resolve most of the disputes that is before this court in terms of the church's constitution and the factions, my lord. My lord, then my colleague made the assertion that the council in 2017 became defunct. I need to draw my lord's attention to the fact that the first applicant was elected to be on the council, be one of 30 members on the council, my lord was showing the page. But thereafter, and that is exactly what Justice Colopin wanted to happen. But thereafter, unconstitutional behavior started to set in. They acted as they wanted to and as not, that was never the intention. And that is where the problem came in, and that is where a lot of the concerns from the first applicant's side came in, is that we need to go back to what Justice Colopin wanted, because that would propel us forward.
But is that feasible? I mean, you've got an exco that was appointed in 2017. Some of those people might have moved away, some of them might have passed away. What do you do now? Surely you must have an election at some stage.
Indeed, my lord, but now you're also sitting with a position where do we have one exco? Do we have 3 exco?
No, that's a problem. It's a major problem.
So it will have to be I want to use the term.
So of which one is your client a member?
My lord, we are currently not aligning with any of the factions. They are merely. I cannot. That has been our contentious from the start, and that is where we say our rights has been infringed on as well, because we cannot associate. With
So the fact of the matter is that original exco that governed the entire church as a whole doesn't exist anymore. There are now 3 excos each running a part of the church.
My lord, that is the most probable scenario, because I cannot
No, that is it. That's it, Ms. Pereira. So if that is so, of which exco is your client a member?
My lord, I cannot. That is not
None.
on papers. I cannot. No, my lord.
He can't be a member of any of those excos because they're new organizations that have been created for each faction.
He was never a member of the exco. He was only a council member. One of the 30.
Sorry, the council, yeah.
As it pleases the court, my lord. My lord, but that is why we are saying we have to go back to what Justice Colopin intended for this to be, because we were well on our way to resolve this matter, and then the other 2 applications which were subsequently withdrawn was brought. So
Right.
if effect was given to be ordered by Justice Collison. I would not to go as far as to say we would not be here today.
Exactly. You're 100%
But
right.
from there, we then resulted in 3 comforters and 3 factions, my lord, which
I
is not to the benefit of any of these
fully
churches.
agree with you, Ms. Barrera, 100% right. What's the solution? That's the problem.
Indeed, my lord, and that is why we require the intervention of this court, as this instability cannot continue, my lord.
Understand.
My lord, may I briefly take instruction
Of
from
course,
my
yes.
lord?
Yes.
My lord, the last thing that I need to address, unless my lord have any other questions, is the issue of costs. We are of the view, and I have cited the Bauer Trust case, as my lord would have noted, that we are seeking substantive relief, Part A. We will come back later for Part B once Part A has been resolved. But the actions of the first, second, and third respondent has resulted in this application being necessitated. As I also stated earlier, in the event that the Bahlane matters weren't withdrawn, we probably would also not have been here. And that was as a direct consequence of the second and the third respondent. My lord, the unconstitutionality of how the first respondent came into his successive position has also necessitated us to bring this application. The applicants are saying that they are bona fide in bringing this application, and they merely want this matter to be resolved so that one church, one faction, and unity. But the church can again...
No, I've heard that argument,
And in
Ms.
that
Barrera.
regard,
What do you say about cost, though?
we are seeking costs against the respondents because it is their actions that essentially necessitated us in bringing this. And my lord would have had, I have made lengthy submissions in this, in my heads of argument. My lord, I have no further submissions unless my lord...
I think I'm fine. Thank you.
Your Lord, may I then be indulged 30-second points. First of all, to answer your Lordship's question, the matter in 2023 was 1 day of trial, July 23. It was another year before the applicants came to court.
Yes.
Even excluding all of the rest of the delay. That's a year. Secondly, I'm surprised to hear my learned friend say that they're asserting a religious right or religious freedom, and I've already given your lordships the sites in which they specifically say that they are not directly espousing a religious right.
Right, thank you, Mr. Osborne. All right, thank you, Counsel, everyone, for your submissions. They're much appreciated. Judgment is reserved. And good luck to you, Ms. Barrera. Right, we're adjourned.
Try to do something. I'll see how no, you can just
We are back from the court. We were inside. The proceedings started in the morning up until this time. The proceedings have been completed. Basically, like we reported earlier on, is that today there were supposed to have been 2 court sessions. One court session was supposed to be an eviction application, which is combined with the Standard Bank application for monies that were stolen by the thieves who believe they are the leaders of this church when they are not, and the eviction as well. So the other matter was relating to a dispute of leadership that some group of applicants who they call themselves of the spirit, Bamoya, they decided that they are disputing the leadership of our father and all others who are imposing themselves as the leaders of IPHC. So they brought that application. What they said inside basically is contradicting the facts that are in place. For 8 years that they've been sitting there watching over other proceedings that were happening regarding leadership, to a point where the 2 brothers withdraw permanently in July 2023. So now they are coming up now. They don't have points. They don't know what they are saying. So now, however, be that as it may, the judge took his time to listen to the matter. So the matter is concluded and the judgment is reserved in that matter. So what we want to say is, of course, while the judgment is reserved on that leadership dispute matter, it's not the major, there's no dispute in leadership, as it were. We know for a fact that the people that are here are IPHC, is IPHC. Anyone who claims to be IPHC is fooling him or herself. So the IPHC is the one that is here. Everyone who believes and thinks is IPHC, he should be here at this point in time. So the next point, now, the interesting part is you all know that we were supposed to have had the eviction and Standard Bank matter. Now, there were issues around the incompetence of the judiciary, that they did not allocate the judge, and yet this matter was already set down in October 2025. And yet, in the last minute, no one knows what is happening, no charge is allocated. The interesting part is those who are supposed to be here, especially the faction that is led by Leonard Modise, is not here, and yet we are here. How come did they know that this matter will be postponed? And we are here. So there's some sort of a collaboration of sort that we suspect that happens. And these are just allegations for now. But it's very interesting. Nevertheless, as we always say, there's no day that does not come to pass. A day will come. So aluko usuku elingafiki. So that day will come. Therefore, the court has promised that they will set down the eviction and Standard Bank matter between April and June this year. So we are waiting for that date. Between April and June this year for that eviction and Standard Bank matter. Don't be fooled by anyone who says the eviction doesn't exist, the eviction is not there. The eviction is there. Those illegal occupants at Ziribacom, they like it or not, they must come to court and take a stand and tell why did they occupy Ziribacom illegally. They have no choice. They can run, but they cannot hide. Thank you.